I'm very pleased to be introducing Professor Marla Sandys, whose academic home is the Criminal Justice Department at Indiana University. Professor Sandys is a social psychologist. She has made extensive study of decision-making by juries in death penalty cases. She's testified in numerous cases as an expert witness. She was a participant and a longtime researcher with the Capital Jury Project, a very ambitious research endeavor funded by the National Science Foundation. So thank you for joining us, Marla. Could you begin by just describing the origins and the objectives of the Capital Jury Project?
Sure. Thanks so much, Jim. It's really my honor and pleasure to be interviewed and chatting with you today. The Capital Jury Project began, it was really Bill Bauer's brainchild. And he really was struck by the US Supreme Court's sort of lack of attention to jurors, and the sense really in McCleskey, where they said, how would actual jurors behave? And that we didn't really know if you were really concerned about how the actual jurors in that particular case would have behaved, as opposed to looking at it in a systemic way. And Bill's response was, great, you want to know how actual jurors in actual cases respond? Let's go for it. And so, Bill reached out to a variety of people across the country, trying to get as many experts and newbies, I will say, in many thanks to Bill for that support, and trying to get as many different people from a variety of different perspectives together to sit together around tables and try to come up with some ideas about how is it that actual jurors in actual cases make their decisions. And so that was really the premise of it. Let's find out how these actual jurors in actual cases come to make their decisions in capital cases.
And that, of course, is extraordinarily challenging because once a jury goes back to deliberate, the doors are closed and privacy is the rule. So what's the methodology for trying to find out how those people are actually making these life and death decisions?
Trying to find them. I mean, really what we did was we wrote letters. We looked through cases where they sometimes would list the names of these actual jurors who served, looking through jury selection, the transcripts, and trying to sending them letters initially, informing them that we would try to reach out. Somebody from the research team would reach out to them. And if we didn't have their contact information in terms of a phone number, we provided a way for them to respond back to us if they were willing to be interviewed. We called them, afterwards, like a week or so later, did a follow-up and asked if they would be interested and willing to be interviewed. And the vast majority, although I have to admit, I don't know off the top of my head what percentage, but the vast majority of them said yes. I think because for many of these people, it was a critical experience for them in their lives, and here were researchers wanting to come in and understand from their perspective what they went through. And while they could talk about it to others, maybe others didn't really quite grasp what it was that they were going through. And so as researchers, we went in and said, come on, tell us. We're fascinated to hear what it is that you experienced as being a capital juror.
So roughly, how many jurors did you track down, and in how many states were these juries sitting?
The initial phase was 14 separate states. We ended up with approximately 1,200 interviews across those 14 states. The goal was to select approximately equal numbers of jurors who had served on both death and life cases in each of those jurisdictions. And at one point, I know Bill had done some sort of review, and we had I don't know, something like 365 separate cases, and we accounted for something like 75% of the people who were then on death row. Obviously, those numbers have changed and the like, but it was a vast undertaking. Yeah.
Boy, I can imagine. So the premise is we have a statute, a system of law that is designed to kind of harness sentencing discretion. And the typical statute asks jurors to think about aggravating circumstances that would suggest that a death sentence is appropriate, and then mitigating circumstances, which would suggest that there perhaps are reasons in this case to prefer a life sentence over death, and to make some sort of a balance between the two and arrive at a very important decision: should this person live or die? And what are the findings in general about how the legal premises that were balancing aggravators and mitigators and determining a sentence, that we've cabined discretion? Does that square with the findings of the Capital Jury Project?
The short answer is no, but I'm going to take a step back before even getting to that, if you don't mind, because one of the premises of the court as well is when they reinstituted, as you well know, the death penalty, they adopted these bifurcated proceedings. And that really is this assumption that the jurors would wait until the penalty phase of the trial or the sentencing phase of the trial to make that determination, to consider aggravators and mitigators in terms of the decision, that awesome decision of life or death. And what we found in the Capital Jury Project very broadly is that approximately 50% of the jurors say they remain, uncertain, right? They did not know exactly what the penalty should be by the end of the guilt phase. But the flip side of that is that approximately 50% of them said that they did know what the penalty should be by the end of the guilt phase. And of those, so if we got 50% who say they remain undecided, we ended up with about 30% who said that they favored death and 20% that favored life. And so there's a lot of this early decision making that is happening in capital cases. And then we jump to the question that you asked in terms of aggravators and mitigators. And so you put it in context, because what happens is that several of the jurors have already made up their minds about what the penalty should be. And then when you get into the discussions about the aggravators and mitigators, jurors understand, and so I'm going to jump to sort of instructions as well in this combination, but jurors understand the instructions for the most part, especially as they pertain to aggravation, because it's consistent with our lay definitions of what of how we make decisions in trials, right? That you have to have a unanimous decision. There has to be proof beyond a reasonable doubt. There's all of these kinds of considerations that that make sense to the jurors. They're consistent with what they know coming into court. Instructions on mitigators are not consistent. And so oftentimes what you find is that the jurors do not understand necessarily what is supposed to be guiding them, so that they don't necessarily understand that mitigation is important. An individual juror's determination of a possible mitigator is important. And so sometimes they, by not understanding the instructions, may be dismissing some of that mitigation.
Well, so what the courts and the legislatures have constructed, and what goes on in these jury rooms, is not in terribly good sync, it would appear. Let's circle back to what you were, how you began this, when Bill Bowers, who I know is your very good friend and regrettably passed away a few years ago, had this revelation about, well, let's see, because the court in McCleskey said that we need to know this. Now that we know what we know from the findings of the Capital Jury Project, You've testified as an expert witness in cases. I'm sure you're aware of appellate court reception of these findings. Have the courts listened to the empirical evidence, or what kind of a difference do you suppose these findings have made?
Whew. My inclination, there my inclination is to say that the findings have not had much of an impact, although I don't necessarily think that's fair, because I think what happens is, particular judges in particular cases may be receptive, and I see the receptivity more in terms of the conditions of voir dire. So while there may not be systemic responses, there may not be legislative responses that have changed, I do think that in specific cases, you'll see changes to the, let's say, the voir dire, the conditions of voir dire. So there may be changes also to the specific instructions that have been used. So that would be my gut sort of response to that.
Well, the long and short of it is that the uh, the expectation that the law would channel decision making is still what most of the courts are relying on, as opposed to taking a serious look at some of the findings of the research evidence. That's well, do you suppose we're getting a little perhaps beyond what you as a researcher can comment on, but is there a way, in your opinion, to well, let me back up. Once upon a time, the Supreme before Furman versus Georgia was decided in McArthur versus California in 1971, the court said it's beyond human ability to have a template for guiding jurors in their sentencing decisions. It's such a ethical, moral decision that the law has limited role to play. Uh, can I just get your opinion about whether we're in a futile exercise to believe that we can effectively eliminate illegitimate considerations and arbitrariness from sentencing, or would there be a way so that the law and practice more closely conform? I know that's a mouthful, but if you have any thoughts about that.
Whew. As a social scientist, I would like to think that there's always a way to improve particular systems. And I would suggest that there's been quite a bit of empirical work outside of, let's say, the Capital Jury Project, let's say, where they have attempted to improve instructions.
Right.
And so are there things that could be done to make it better? Yes. Would it be sufficient to eliminate arbitrariness and some of these other biases that influence the system? Probably not. And the reason I say that is because you know, I often say when I speak to lawyers, and maybe I shouldn't be saying this, but to me, the law is a beautiful theory of how things are supposed to operate. And as somebody who is not trained in the law, and I don't know how to think like a lawyer, which I understand is what you get through law school, I don't have that, right? So I look at that and say, the law tells us these are wonderful hypotheses about human behavior. And that's why, to me, let's say the Capital Jury Project or other empirical research based on these kinds of questions are so important and intriguing. I think the law assumes that people can do what lawyers are taught to do by going to law school. And I don't know that we can, without going to law school. So that's where I see the disconnect. Are there things that could be done that could improve it? Absolutely. In theory, does the law work in, particular ways? Absolutely. The morality, that's not a discussion that I'm sort of comfortable in having, but I think the disconnect comes between the law looking at his theory and social science saying, wait a second, there's evidence here that doesn't support that that's how humans in reality operate. And so I'm not sure I'm answering your question the way you were thinking I might, but that would be my response.
That's an eloquent response, a very thoughtful one.
Okay.
If I could just focus on one last aspect of the jury process. I know you've done considerable work with death qualification. If you could explain what that is and the effects that it might have with respect to these life and death decisions.
Absolutely. When you say I've done quite a bit, because I started that in my master's, actually, that, that was the question that really struck me. Again, coming at it as a social scientist and not somebody trained in the law, there was this question of whether individuals are qualified to serve on a death penalty case, or you could say, are they qualified to vote for a sentence of death? But that has, changed over time. But the whole idea behind death qualification is, can you serve on a death penalty case? And historically, the question really focused on, could you vote for a sentence of death, right? Did you have any, uh, um, so I often think of it as the pre-Witherspoon. Do you have any conscientious or religious scruples against the death penalty? And if so, you were excluded. And, it's obviously changed over time, to where now there is this novelty of, could you also vote for life? Right? I mean, historically it was just, could your prospective jurors vote for a sentence of death, recognizing the awesome responsibility that that would involve. But then there was a realization that, wait a second, that process may result in individuals who couldn't consider even voting for a sentence of life. And so under the ideal circumstance, again, going back to what the law necessarily thinks about, is you want individuals who could consider aggravators and mitigators, decide on a sentence of death or life. But what the research has demonstrated is that the entire process of how we go about selecting prospective jurors does not result in individuals who, for the most part, are necessarily the most impartial. That the process, so Craig Haney has done, wonderful work looking at the process effect, and that just being that by sitting in the courtroom and watching others be questioned about their ability to vote for a sentence of death prior to there ever being any evidence presented in court, focuses jurors to believe that the person is more guilty, more likely to vote for a sentence of guilt, I should say, more likely to vote for a sentence of death. The flip side of that also is this idea that most people, when you ask them about whether they could vote for a sentence of death, um, realize that that's a difficult question, right? I mean, when you're thinking about having somebody's life or death in your hands, a lot of people would say, I would not automatically vote for a sentence of death. I would want to know what the evidence was. I'd have to consider it in its context, etc. Most people would say that they could consider a sentence of life, right? I mean, we tend to think of that as that might be the default, right? That's where we begin. But what we've also learned is that people don't really know the particulars of these cases. You don't get to sit on a death penalty case and your case doesn't go to trial in a capital case where there isn't some pretty difficult evidence to be considering. And so what some of the research has been able to show us is that people oftentimes, once they get presented with that evidence and once they become convinced beyond a reasonable doubt that the person is guilty of that offense, then they think that death is the required or the most appropriate penalty. And discovering who those individuals are at the outset is a really difficult task for attorneys. And so that has been known as, let's say, the automatic death penalty voter. So if you ask people at the outset, would you always vote for death? They say no. No. I'd want to hear all the evidence and the like. But what we find, and this comes from the Capital Jury Project, that when we ask them at the, could you consider additional evidence? They say, of course I could. And then when you look at how they made their decisions, you have a high percentage of them that are saying they're making it based on the guilt phase evidence alone. And that once they made that determination, they really did not think that any additional information would have been important and the like. And so that process of qualifying the jury, when I said to you before that one of the ways in which the capital jury has had an impact, I think, is in the conditions of voir dire, is recognizing that you need to be able to unpack that for jurors at the outset of the trial and to get a sense of, this is the kinds of evidence you're going to be hearing. What do you want to know about that particular individual who may be accused of that? What do you want to know about that person before you would be willing to make that determination of whether death or life is the most appropriate penalty? And so I think that aside from the process effect of which, Craig Haney has, talked about so eloquently, there's also that idea of trying to get people to talk openly and candidly about the conditions under which and the kinds of evidence that would be important to them to make their determination, so that they recognize that guilt alone is not sufficient for that determination.
I know it varies by jurisdiction rather considerably, but roughly what percentage of people would be excused for cause because they aren't death qualified or not life qualified? It's a substantial percentage, isn't it?
I wish I knew the answer to that. Off the top of my head, I'm sort of drawing a little bit of a blank. But when you think that people who get called in for jury selection, it's not uncommon to call in 200, 400 prospective jurors in order to be able to seat a jury of 12 plus alternates. So they're being excused, for a variety of reasons. And you've got limited numbers of preemptory challenges that exist. So a lot of it is those, excusals for cause, for both people who say they could never vote for death, for people who would say they would always vote for death. And yet, as I said, or I was trying to sort of explain, that I think it's easier to discover at the outset people who would say they would never vote for death, because these are individuals who know that about themselves and they've perhaps thought about those conditions, right? So you could ask somebody, so, you could think of, Ted Bundy, they tend, take these, names of people, Osama bin Laden, could you consider under those circumstances? And somebody who says no is somebody who's never going to vote for a sentence of death. And whereas people who say they it's highly unlikely for people to say they would always vote for a sentence of death under the conditions that sort of render people eligible for a sentence of death, which is why, attorneys often say, it's that death qualification. It's not just that it influences the penalty phase or the sentence that people decide on, it influences the guilt phase as well. That you're coming in and you've deselected groups of individuals that are fundamentally different from people who try non-capital cases, that they come in there with a different perspective on the evidence, and that they're more likely to end up voting for a sentence of guilt, which would also, not a sentence of verdict of guilt, that would then, increase the likelihood of a sentence of death.
Well, these are fascinating, complicated issues. You're doing very important work. I hope you keep doing it. You do it so well. Thank you, Marla, for sharing your thoughts and expertise with us. It's been very informative, very interesting.
My pleasure. Thanks.